I rise today to discuss a tremendously important case that was argued this morning in the Supreme Court. The case is King versus Burwell, and it involves the administration of Obamacare. I was privileged to attend the argument. Mr. President, the King case is important for a number of reasons. It's important because it involves a fundamental component of Obamacare, and it's important because of its significant implications for the rule of law. From the early days of the Republic, a core component of our constitutional character has been the idea that the government is a government of laws and not of men. That means that our leaders are constrained by the words of the laws in our statutes and in our Constitution. Government officials must follow the law, even when their personal preferences would lead them in a different direction. The current administration, however, is engaged in a sustained assault on the rule of law. I've spoken many times on the Senate floor about the president's disturbing disregard for the separation of powers and other limits on his authority. His offenses run the gamut from releasing Guantanamo detainees without first notifying Congress to claiming that congressional inaction somehow clothes him with legislative-like authority to suspend immigration laws, to arrogating to himself the power to determine when Congress is in session. Mr. President, President Obama's actions in the King case are of a piece with the other executive overreaches. First, some background. Obamacare requires every person in America to buy health insurance. This is the so-called individual mandate that the Supreme Court controversially upheld 3 years ago. Most Americans receive health insurance through their employer, which pays a large part of the premium. But not all do. Many must purchase insurance on their own, and to ensure that such individuals are able to comply with the individual mandate, Obamacare directs states to create health care exchanges, government-operated websites where consumers can go to compare and choose insurance plans. Obamacare also provides subsidies for individuals who purchase insurance through these state-run exchanges. Remember that most people receive health insurance through their employer, and that their employer pays part of the premium. Individuals who purchase insurance on their own through exchanges, however, don't receive this employer subsidy, so they must contribute more towards the premium themselves. Obamacare provides subsidies to these individuals to help offset the cost of insurance. And with that background, Mr. President, let me turn now to the legal issue in King. As I have described, Obamacare directs states to establish health care exchanges. To be precise, the law says, quote, each state shall, not later than January 1st, 2014, establish an exchange, unquote. That meets certain conditions set forth in the law. But there's a wrinkle. The Constitution does not permit the federal government to order states to do things. This is called the anti-commandeering principle and is well established in Supreme Court case law. What the federal court can do, however, is incentivize states to act, and that's precisely what Congress attempted to do with Obamacare. Here's how the incentive works. Another provision of Obamacare, the one at the heart of the King, conditions the aforementioned subsidies on an individual's enrollment in a state-run exchange. According to this provision, a subscriber is eligible for a subsidy for each month she is covered by a plan that she, quote, enrolled in through an exchange established by the state, unquote. The text of this provision could not be more clear. If an individual enrolls in a plan through an exchange established by the state, she gets a subsidy. If she enrolls in any other plan, no subsidy. The incentive for states to act also could not be more clear. If a state fails to establish an exchange, its citizens lose out on millions of dollars. Obamacare's proponents quite reasonably thought this would lead states to set up exchanges and would thus accomplish the same result: creation of state-run exchanges that Congress could not achieve through direct command. In fact, I actually heard arguments by administration people that if they put enough pressure on the states, we'll do this. Congress also recognized, however, that some states might not take the deal. Thus, it provided a backstop. And yet another provision of Obamacare. Congress instructed that if a state does not set up an exchange by the January 2014 deadline, the Department of Health and Human Services shall, quote, establish and operate such exchange within the state, unquote. Crucially, however, Congress did not similarly provide that subsidies would be available to subscribers enrolling through a federally established exchange. And the reason is obvious. If subsidies were available under both state and federal exchanges, states would not have any incentive to create their own exchanges because the subsidies would come either way. Fewer states would create exchanges, meaning the federal government would have to step in and create more exchanges on its own or of its own. The restriction of subsidies to state-established exchanges was thus a key element of Obamacare's entire cooperative federalism scheme. Without this restriction, the end result would have been a federally run healthcare market, a result unacceptable to several key Obamacare supporters whose votes were essential to passage of the bill. Now we come to President Obama's act of overreach. Notwithstanding the unmistakably clear text of the statute, which limits subsidies to plans purchased through state-established exchanges, and notwithstanding that this limitation was absolutely fundamental to accomplishing Congress's purpose of incentivizing states to establish exchanges, the President decided that he would also offer subsidies for plans purchased through federally established exchanges. Mr. President, President Obama's open defiance of clear statutory text and utter disregard for the balance Congress struck is an affront to the separation of powers and to the rule of law. The President and his enablers argue that subsidies for federally enrolled plans are necessary to accomplish Obamacare's overall purpose of reducing costs and improving health care access. Without subsidies to individuals in the 34 states without state-run exchanges, the President argues residents of those states will be hit with higher costs and unaffordable health care. The law must be rewritten, he says, to avoid the consequences the law itself imposes. Laying aside the fact that the Constitution gives Congress, not the President, the power to amend laws, the President's argument is completely circuitous. The reason 34 states could afford not to establish exchanges is because the President said he was going to pay subsidies regardless of whether a state establishes an exchange. Why would a state go to the trouble and expense of creating an exchange if the end result is the same? The President also grasped at exceedingly thin textual straws because the backstop provision instructs that if a state does not establish an exchange, HHS shall step in and establish such exchange itself. The President says this means that federal exchanges are state exchanges. Right is left and up is down. But let's return to the real provision in dispute in King, the one that defines eligibility for subsidies. This provision says, again, that an individual is eligible for each month that she is covered by a plan that she, quote, enrolled in through an exchange established by the state, unquote. I underline that. An exchange established by the federal government is by definition not an exchange established by the state, regardless of whether the federal exchange is a backstop or not. And it gets even worse for the President because the provision additionally specifies that the state exchange must have been established, quote, under Section 1311 of the statute, unquote. That section sets forth the requirements for creating state-run exchanges. Nowhere does it mention federal exchanges. Rather, the conditions for creation of federal exchanges appear in a different section, Section 1321. Under no plausible reading of the text does a state exchange established under Section 1311 mean a federal exchange established under Section 1321. Mr. President, advocates of the President's position would have us believe that statutes are infinitely malleable Up can mean down, right can mean left, established by a state can mean not established by a state. What matters to them is advancing some vague notion of statutory purpose that coheres with the president's left-wing agenda, regardless of what the statute actually says. Those of us on the other side, however, insist that text matters. Words matter. What the statute says is what matters, because at the end of the day, the words in our statutes and in our Constitution are what bind our leaders and what prevent them from doing whatever they want. Mr. President, the administration's actions in King have undermined the rule of law and contravened important constitutional checks on the president's authority. As has increasingly become the case under President Obama, it is now up to the Supreme Court to rein in the president's overreach and to reaffirm the fundamental obligation of all government officials to follow the law. I surely hope the court will do so.